Yuli, and the future of law reporting. In that session, we shall have His Worship Joel, and you explore the role of the legal technology in improving access to the law, with a spotlight on Yuli, the Uganda Legal Information Institute. The discussion will be led by him, like I've said. He's the Senior Magistrate Grade 1 and the Head of Law Reporting at the Judiciary Training Institute. We are grateful to have knowledgeable speakers with us today, and I encourage all of you to engage them when that session comes for questions, to make sure we understand very well. Thank you once again. You are all welcome. I will now invite the Head of Rule of Law to the podium here.
Thank you, CEO. Good morning. My name is Apio Afra. I'm the Head Rule of Law, Uganda Law Society, and I warmly welcome you to today's Rnblive session. Our first issue will be succession law, understanding key amendments in the Succession Amendment Act 2022. In 2022, the Succession Amendment Act was enacted, introducing significant changes to how estates are managed and distributed in Uganda. One key provision that has drawn considerable public attention is the notice from the High Court Family Division stating that grants of letters of probate and letters of administration issued before May 2022 will expire on 31st May 2025. This announcement has understandably sparked fear, confusion, and widespread debate. Today, we are privileged to have with us a distinguished speaker who will help us unpack what this provision truly means. What does expiry of these grants entail? What should affected families do? And more broadly, what other critical changes does the amended law bring that we all need to be aware of? To unpack all this, we are privileged to be joined by Mr. Kuloba Wesaka Henry to discuss the topic, Succession Law, Understanding Key Amendments in the Succession Amendment Act 2022. Mr. Kuloba is the Assistant Administrator General and Head of the Litigation in the Administrator General's Office, where he has worked for the last 14 years. He is also an Assistant Lecturer at Law Development Center, teaching family law practice and land transactions. He holds a Master's of Law in International Commercial Law at the University of Salford, that's in Manchester. He also holds a Bachelor of Laws, Makerere University, and a Diploma in Legal Practice from the Law Development Center. Mr. Kuloba, you're welcome.
Thank you very much, the organizers and the protocol observed. Yes, it is true that in the past 1 week, there has been a lot of concern raised through both social media and mainstream media about the impending expiry of letters of administration. But what I like about the topic that I was given is that it broadly talked about the key amendments that were introduced to the Succession Act. And like I have always said, succession law falls under personal law. That's why it affects people directly. regardless of status in society, from a peasant even up to the head of or the first citizen. All people are subject to this succession. It is important, therefore, to know that the amendments were many, and I'll eventually zero down on the expiry, but it is important that the general public knows that a raft of changes were made to the succession laws, which many people may not know about, and we don't want that to be clouded by just only the expiry, because in about 2005, some women activists petitioned the Constitutional Court to declare some provisions of the Succession Act unconstitutional. But key among those provisions was Section 27 then, which provided for shares in an estate. So law advocacy for women versus Attorney General in the Constitutional Court. And specifically they were saying that the share that was given to surviving spouses when they lose their husband or wife, which is 15% of the estate, was discriminatory and unconstitutional. And they were saying 15% did not, for example, take into account polygamous families, which are very prevalent in the Ugandan society. Because under polygamy, it means a man can, for example, marry even 20 women under polygamous or customary marriage. So if we had 20 women, all of them were supposed to share the 15%, which could become negligible, actually. So amongst other sections of the Succession Act, the Constitutional Court indeed declared that section of 27 as unconstitutional. But when the Uganda Law Reform Commission now undertook to revise the Succession Act, it decided to take a broader look, not only those provisions that were before the Constitutional Court. Because as you know, succession law being sensitive, just like the Marriage Act, we all know that the Marriage Act has been in Parliament for over 50 years. These are not very easily amendable laws because of obvious reasons that I've stated. It has a lot of personal and emotions usually. You have seen what happens in Parliament whenever the marriage bill comes to the floor. You all know what happens. And it has failed to take off. So it is little wonder that even the Succession Act took 50 years to amend the Succession Act, because it was last amended in 1972, then in 2022, those are 50 years. So they are not easily amended because of emotions. I always give this example that, for example, you can amend the Trademark Act in Parliament and no one will actually know, apart from people who are in that field of maybe trademarks. Even some lawyers may not know about it. But if you touch the Land Act, everybody will know about it. And everybody will have an opinion about the Land Act. So the Succession Act now took, the Uganda Law Reform Commission took a broader approach and amended a number of provisions in the Succession Act, eventually. For example, we had a contentious issue on stepsons and stepdaughters. And the old act was defining a child to include a stepson or a stepdaughter. And a good example would be, for example, if a woman comes to get married, but she comes, let's say, with a child who is not of that, who doesn't belong to the man, but she comes with a child. And the issue is that when the man dies, if the woman came with a child 1 year old and he has grown up in that family as if a child of that man, the succession law was implying that that child would benefit from that estate. So during this amendment, there was a lot of emotions about it, but eventually they deleted any reference to a stepson or a stepdaughter. And as we talk now, those people cannot benefit from an estate of a deceased person. They removed terms such as illegitimate children, because the Succession Act still was talking of illegitimate children. And yet, under our Ugandan society, even case law has established that there is nothing like an illegitimate child. Most families have these children, and at times they are looked at as if they are different from the children of the marriage. So, for example, a married couple has 5 children, and then maybe a man has a child from outside that marriage. They used to be termed illegitimate, and that is English law, because in England, for them, they have those illegitimate children if you are born out of wedlock, and then they also have mistresses and so on and so forth. So our law, having emanated from England, we had those terms as illegitimate. But in a Ugandan society, that is not the case. So they removed any reference to illegitimate children. I'm just briefly mentioning the key amendments. Of course, the issue of the heir or heir, customary heir, the Succession Act has given an impression that only men or boys could be heirs. And especially some cultures, actually, you can't talk to them about a girl being a customary heiress. It is almost unheard of in some societies in Uganda. And I think you all remember a prominent person died, the former prime minister of this country. He died and left a will where he named his daughter as a heiress. Prominent Muganda man, and you all heard the noise from Mengo that not at all. How can a girl be a heir or heiress? And they have their own cultural justifications, and it makes sense a little bit, but it is discriminatory under the current constitutional dispensation. So now, the Succession Act amendment made it clear that even girls can be heiresses. The other was on dependent relative, which at times is of course confused for a dependent, because in Uganda, to benefit from an estate of somebody who has died, a dependent relative, the person you should have been dependent on the deceased, but also related to the deceased. So that's why it is dependent relative and not dependent, because dependent is so broad, it can even mean somebody who was not related to you, whom you picked from the street and you were looking after. But the law is restricting it to dependent relative. In other words, you should be related to the deceased by blood, either a nephew, a niece, a uncle, sister, whatever. There must be blood. But also previously, for that person to qualify, the law is saying that you are supposed to be substantially dependent on the deceased. Substantially, not wholly. Now the amendment changes the whole thing and says you must be wholly dependent on the deceased in order for you to claim a share as a dependent relative. So then there were changes that were made on a will, a will, especially on the signing of a will and witnessing it. That provision that there must be signing of all pages of the will. It is good practice, even if it was not to be embedded in the law, that your will is signed on all pages to avoid issues of fraud. Yes. They don't need to go through yes, because it was possible that a man can have children outside wedlock, and it is rampant. And usually those children are discovered after the death in most cases. And yet our law doesn't discriminate children, that these are from a married, from the marriage, and then these ones are from outside and what. There's no distinction between the children. So the issue of a woman automatically applying was amended slightly because of children who are not hers. So to avoid that, they said that now a widow can also be vetted by the Administrator General. In other words, you come to the Office of Administrator General and we do thorough investigations to find out, did the deceased have children with you alone, even if you are legally married to him. And in most cases, those children come up during those investigative meetings. And once they come up, we then now have to have administration, maybe joint administration, to cater for those children who are not from the legal marriage. So that is also a very important aspect of the amendment. Of course, the other was to change or revise the percentages. Previously, the widow was getting 15%. The women activists and women parliamentarians had suggested that a woman or a wife or the surviving spouse should get 50% of the estate, but that was declined by Parliament, and they said the surviving spouse should only get 20%. The children remained at 75%. Dependent relatives get 4%, and then the customary heir gets 1%. Then the other issue that was also quite contentious was what happens when, for example, a woman remarries after the death of the husband, and does she still get a share if she remarries? Because the law doesn't stop a woman, for example, or a widow from remarrying after the death of the husband. She's free. And the man is also free to get another wife. The wife is free to get another man upon death. But the issue is that if she remarries, can she come back during the distribution of the estate and say, yes, I want my share? And after debate in Parliament, which was also heated, they agreed that yes, she should come back and get her 20%. Why? Why would you? Because the marriage was ended by death. So she's entitled to 20%. And she's also entitled to remarry. So the issue is that she can still come back and get her 20%. The other was now on a separation, because, and it happens a lot, that a man dies, but at the time he dies, they had separated with the woman. It is a very common occurrence, because after the death, the women or woman usually comes back. So at the time of death, they have separated, they are living apart. But after the death, she comes or he comes back. Usually it is she. Because she's the one who moves out of the home, and there's that separation. So the law was that when you have separated from the person, you are not entitled to a share when that man dies. And that is still the principle, that separation for 2 years, for example, prior to death of the man, then you are not entitled to a share. And the law is only giving an exception, for example, where you had gone for study. They call it the approved course of study. That if you were on a study leave, yes, that is understandable. But Parliament introduced other exceptions. For example, the wife had left the home, but the person who caused the separation is the man. So the woman didn't go or didn't separate on her own. She was forced to separate because of the man. So the man caused the separation. So the Parliament just brought in some exceptions. Or the man is the one who has left the home, and that happens a lot. So these days it is not a woman leaving the home, which is now physical separation and going elsewhere, but the men also leave women in the home and they go away. So he has a home in Endeavor with his wife, and then he abandons the home and goes and stays in Mukono. Now there is a separation, but now the law is saying, she has to benefit from your estate because you are the one who went away. It is not her fault that there was separation. So it is a very, those are very dicey issues of personal issues that the amendment touched on. And then maybe finally was on the home, saying that a home where the deceased was staying should not be subject to distribution, because previously people would, when a man dies, the home is sold off. And that is especially where a man has left the home as maybe the only property, or it is the most prime property. And it happens a lot. For example, when a man is just beginning in life, he has a modest home with his first wife. Usually it is modest. Then as he grows up and accumulates wealth and gets wealthier, men, not all of them, but some men, decide to take on another younger woman. And usually that young woman, now let's say the man was the first marriage in 1990, the home might be somewhere in the village. And usually the younger one now gets a home somewhere in town which is more prime. So, serious war erupts there after the death. The family in Gomba, when it hears that there is another home in Muyenga, they used to say, yes, all this is property of our father. We are all entitled. So they would invite, they would say, the Muyenga people, if you want, you are also free to come and stay here in Gomba. And we are also free, those of Gomba, to go and stay in Muyenga. And when it came to distribution, they would say, let's sell. Let's put these things in a pool, we sell and we share. So there was that lacuna, and the parliament had to come in and say, no. When a man dies and he has many homes, stay where you are at the time of death. Don't start now saying, but now I need, we are also entitled to that Kololo mansion. Stay where you are to avoid confusion. Very contentious, because some people come and say, but for us, he was renting for us. I mean, he was just renting in why is it for us? And yet there is a very comfortable home in Muyenga or elsewhere. Why should we suffer? Very contentious issue. Practically, the law is there, but practically, some of us who deal with these things face a lot of issues. Now, back now to the one that has caused the excitement, the one on expire of letters of administration. As you all know, previously when people got letters of administration, the whole country was in a slumber. Administrators have letters of administration, but some of them even don't know that they have letters of administration. They got letters of administration in 1990, for example, and he has even forgotten that he got letters of administration. So he even has no copy. There is one who came to office and I told him, you go to the family division and they check for you, and they discovered indeed he was granted letters of administration in 1992. And he had not done anything with the estate. He had even misplaced the letters of administration. There are people with the letters of administration of 1975. Because as you know, the Succession Act starts applying to Ugandans in 1972. So, people have letters of administration, but they have never done anything. Or they are doing things wrongly. Taking on properties, not distributing to the entitled beneficiaries. And therefore, Parliament was of the view that, first of all, we need to awaken the sleeping administrators. So to me, actually, while people are doing this, for me, I see the law is working now. Because people are awakened from sleep. The concerns you are hearing is that now people are awakened from sleep. It's like when you are sleeping and then somebody comes and pours cold water on you. That is what the intention was. So now the issue is, if you have letters of administration issued in 1980, so today is now 40, those are 45 years. There is need for you to come and tell court, what have you done in the 45 years? What do the beneficiaries say? Have you been a good administrator? That's why they are saying extended, but with the consent of the beneficiaries. So the beneficiaries have to tell us, in the 45 years, what has this man or woman done? Are you happy with it? You'll be shocked. The stories that are going to come up. So Parliament said one, because it gave different timelines, 3 of them. So 31st May 2022. That is the date when the amendment comes into effect. So it is a very important date for us to understand all these other periods that we are going to talk about. So they are saying that any letters of administration granted before 31st May 2022 were given 3 years. 3 years to expire. 3 years from when? From 31st May 2022, meaning expire 31st May 2025. So any grant issued in the 70s, in the 80s, in the 90s, in the 2000s, those categories. And in the 2000s up to 31st May 2022 were given 3 years to expire. So that is the first category, and those are the ones that many people are concerned about because there are many. They are in their thousands, so many actually. Now the second category are those now that were issued after the amendment. So after 31st May 2022, courts issued the letters of administration from that date. Now those ones after the amendment had come into force were given 2 years. So those ones have already even expired, and actually people have been applying and extending them. So those ones should not cause a lot of alarm because I know and I have seen very many that people have extended. Those are 31st May 2022 up to now. And with them, the courts even indicate the exact expiry date. So if you get, for example, today is the 22nd May 2025, the court will indicate on the letters that this letter will expire on the 22nd of May 2027. So that is the second category. The third category, which is also very important because it involves again the general public, but people are not talking about it much, are letters of administration issued to the Administrator General. Now, Administrator General also has letters of administration on estates issued by court. Some people, some families even don't know that Administrator General has letters on their estates, especially the grandchildren and so on and so forth. So it is only when they come to process them, and then we say, but Administrator General got letters in 1990. But people were in slumber, they were not following up their interests. So the Administrator General for him, unlike private persons who were given 3 years, the Administrator General for him was given 5 years. So in other words, the letters of administration issued to the Administrator General before 31st May 2022 are going to expire on 31st May 2027. So any family that has Administrator General as the administrator of the estate, and there are so many, our letters will expire in 2027, 31st May 2027. So, these categories, Parliament put a remedy of extension. So it is not doom and gloom like it was being stated in various social media and mainstream media, as if people are going to lose property, as if people somehow there's a crisis. No, the law provides for extension of letters of administration. And even when they have expired, because some judges have actually said that you can't apply for extension when it is still running. So to extend what? So it is after expiry, you have to go to court and give justification why the period should be extended. Very important, because administrators, much as they are trustees, administrators thought that they are the owners of property. There was that misconception. When an administrator gets letters of administration, they think that they are owners of the property. And some beneficiaries have never benefited from their father's estate because administrators think that it is their property. So it is important that when they give you power, you should come back to court and tell court why you need more time. And the beneficiaries should tell court that yes, we have no problem with him. Actually, he just has issues with court cases. He has issues with this. But as an administrator, he has done well. The beneficiaries must give a consent before they extend those letters. So, those people, after 31st May, all administrators in Uganda, you are supposed to account, because many have not accounted for the properties they have managed for the last 40, 30, 20 years. Why should we extend it? But the law has also provided for exceptions. For example, where the estate is receiving pension. If your father, for example, was a civil servant, and let's say a police officer, and is entitled to pension, usually they pay for a long period, pension, about 15 years, depending on how they have calculated it. So those letters only expire after you people have finished receiving the pension. So that is also something that did not come out clearly and was causing alarm. Estates receiving pension, since pension takes time, the letters will not expire until the pension is exhausted. And then also estates where the beneficiaries are below 18 years and the guardian has got letters of administration. Let's say guardian gets a letter of administration on an estate of children below 18. Let's say 10 years. If it is 10 years, the law is saying that the letters of administration will only terminate upon the children acquiring majority age. So if somebody is 10 years, then it means the letters of administration will continue for 8 years and then terminate when a child attains 18 years of age. So it is not doom and gloom. It was an awakening measure that administrators are deep asleep. Some of them don't know that they even have letters. Some of them know, but they are doing wrong things, so they don't want to account. Then some of them are just ignorant about their roles, and therefore this awakens them and sets straight the record for administration of estates. So briefly, that is what I wanted to go through with the key amendments, the Succession Act, and then specifically on expiry of letters of administration. I thank you.
Thank you so much, Councillor Kulova, for that elaborate discussion. Good morning, ladies and gentlemen, especially those online who are here with us. I salute you. I'm called Robert Jirua. I'm a member of the Rule of Law Department. I'll be helping to facilitate this session as I moderate. Would like to thank you once again, Councillor Kulova. For you to know, there were some flowers that were given to you from the last presentation. Thank you for visiting us again. We appreciate the members, both online and physically, appreciated your effort, and we are blessed that once again, you've come again to handle a very contentious issue that you've called personal law, which of course touches all of us. We want to thank you for your time and the wisdom that you've shared. We shall hope that that is enough or sufficient to espouse the issue of that of the topic, and believe that the members have information enough to help themselves as well as handle those family matters. Ladies and gentlemen, we are receiving questions because it was a public outcry, amongst other things, and the deadline is coming so close, 31st of May, which is, I think, next week. We know there are so many questions that are being asked by both members and the general public. This is the opportunity. With an expert in the house, we have the opportunity to ask questions, and they are welcome. We shall be taking a time off to answer those questions. In the meantime, we want to thank you once again for your presence and for this Rnblive session. The Honorable Treasurer, we want to thank you so much for gracing the occasion. We bless you and thank you for representing Council. We thank you so much. For those that are online, we are thankful for your time as well, and we would like to move to the next question that is going to be asked in. Yes, what Mr. Kulova has shared happens to be identified in case law, apart from the normal life situations. The beauty with the law is that it touches life situations, and there's case law that is available to explain these situations. And today we are blessed with another expert who is going to help us unpack how the general public and the members can easily access that case law. And that for us is very important, because as the Uganda Law Society, in implementing our mandate and one of our objectives under Section 3 of the Uganda Law Society Act, to espouse and help to handle matters touching the law, especially for the public. Ladies and gentlemen, today we are going to handle legal tech, in which we are having an expert who has already been identified, but also for your information, he is a grade 1, senior magistrate grade 1. He's the head of law reporting in the judiciary of Uganda, with over 7 years of judicial service and 3 years of private legal practice. He brings a wealth of experience in legal adjudication and institutional reform, a dedicated and accomplished chess player. He has represented multiple institutions at distinct levels in that regard. He actively champions the use of chess to foster strategic thinking, discipline, and cognitive development, both within and beyond the community. Ladies and gentlemen, we are privileged to have with us in the house His Worship Joel Wegoye, who is going to take us through the aspect of legal reporting under the auspice of Uganda Legal Information Institute. Please, ladies and gentlemen, welcome with me His Worship Joel Wegoye.
Thank you very much. You will allow me just mention my name again. My name is Joel Wegoye. I am the in charge of law reporting attached to the Judicial Training Institute. Maybe before I get into what I am supposed to say today, about what my brother Kulova was talking about, before I left office today, I uploaded a decision from the Kabale High Court. And it was about a lady who had separated from the husband and and came back to reclaim some property after he had passed on. And as my brother Kulova had said, the court rightly stated that you cannot claim after separation. You understand? So the law is as it is. But maybe for people who may not know, you'll allow me talk about Yuli briefly. Now, Uganda Legal Information Institute, that people refer to as Yuli, is a product of the judiciary of Uganda. What we basically do is provide free legal access to the public, because the business model believes that the law is a public good. Now, Yuli as an institution has a user base of about 200,000 users per month. That means when you're on Yuli, you shouldn't think that you are alone. Probably there are more 200,000 users using the platform. Per month, we go to about 40 different countries. Our users cut across about 40 different countries. And you may think Uganda has the biggest users, but we go as far as Nepal. I don't know if anyone has heard about a city called Kathmandu in Nepal. That's how far we go. So it is a used platform, and it provides free legal access. But you have to be aware that Yuli has been undergoing significant transformation. And the first of it was migrating from the old Yuli website to the new Yuli website and inputting features. So what does Yuli offer? The core of the legal profession is legal research. You can argue about many things welfare, but in order to get into things as welfare of the advocates or any other person in the legal profession, it's giving them the tool of trade, which is legal materials. Yuli has a number of resources it offers. It offers the legislations, the case law, gazettes, the Hansards. And as you might have noticed recently, we do case summaries, fly notes, digests, and many other materials that you'll find on the website. You'll also be alive to the fact that there is nothing as radical as the technology. You sleep one night and wake up in the morning, and everything has changed, and you start from zero. So the most unfortunate thing about technology is that it can forget you if you don't keep at pace with the system. So you have to learn and learn and relearn every day that you live with technology. The system as it is designed to empower the public. Yes, it is designed for the legal profession, majorly in terms of the judicial officers, the lawyers, but also the public, because we have quite a number of members from the public who actually use Yuli. And as you can know, in some debates, you find that people who have no legal training are actually arguing matters in a way that they actually understand the law. And these days, it's very risky for a person with legal training to get into an argument, because you don't know where the axe is going to fall. As you may be alive to the fact that a few weeks or a month back, we had the argument on whether or not the definition of the word girl in the offense of rape was correct. And it pitted so many people against each other. You understand? But if I could relate that to what I've been saying, Yuli has parliamentary Hansards interlinked with court cases. That means if a decision is challenging an act of parliament that was discussed, the Hansard is attached to the court case so that you don't have to go anywhere else to read the decision. But that's one of the many features that Yuli offers. But specifically, you'll also allow me to speak to the training that is being organized for all advocates across the country. It will be a CLE training to be held on the 30th of this month. I'm sure the ULS will communicate to that training. The idea around the training is majorly for advocates to know the changes that have been happening in the last few months on ULI. And why is this so? As a user of ULI, most people use about 5% of the actual technology on ULI. Because most people think you go in, get a case, and get out. But like I have told you, right now, it's not about cases. You have to learn how the law interacts with each other, how the Hansard interacts with the court case, how the court case interacts with the legislations, and all other things. And even how to navigate ULI is totally different from what it was before. As you know right now, things like the general search and the advanced search, where I use the Boolean operators, are quite different. So you have to specifically know how to use them. Secondly, if you realize that all courts are classified, from the Supreme Court to the High Courts are totally separate. So how you access the separate courts to get cases from the different courts will also be explained to you. Now, what do I think? I'm avoiding to go into specific detail because that will be discussed at the training. Now, what is the future of law reporting in Uganda? First of all, I would want to thank all the other reporters in the country and everyone, because we have both entities and institutions that are doing law reporting. And you realize that in Uganda, law reporting has, I don't want to use the word competitive because it's a public good. You cannot compete while giving a public good. You're probably all giving a service to the public. So there are law reporters like Triclaw, Law Point. I know other individual law reporters. So you learn so many things we learn so many things from each other, and day by day we try to improve. But the biggest future about technology is not even about what the changes are. It's about partnerships. I believe that the greatest partnerships as far as technology is concerned is terms of legal entities partnering with each other. I've seen this in Tanzania, where Tanganyika Law Society, the Law Reform Commission, the judiciary have partnered and created the secretariat. And Tanzania is now reporting under secretariat, where all institutions are under one body, and also civil society. And they are doing amazing work. And it's not a unique area. I believe even in Uganda, there will be partnerships. And we have no choice, because it's a tool of trade for the legal profession. And we are too many. And I will say that there's enough space for all people interested in the legal field. Now, another feature I'll tell you currently that is being rolled out in Tanzania is the fact that you can access all legal material on a platform like ULI without the requirement of the internet or with limited internet. The products are normally called street law. That means that a lawyer in Atiak or a lawyer in Kisoro who has limited access to internet or no internet at all will be able to access the same legal materials as a lawyer in Kampala. Now, as you know, Kampala is the prime of areas in Uganda, and most services are here. But we shouldn't forget that there are judicial officers who work way up country, probably without any access to internet. There are advocates who work up country, and they all need to have access to the tools of trade, which is legal materials. Now, the future of law reporting is going to that area. Yes, we needed the internet to report about cases across the country, but where we are going is you may not need internet to actually access all legal materials on the internet. So that is one aspect of the future of law reporting I have noted. I'll also look at legal analytics. Legal analytics has many aspects about it, but I'll specifically dwell on one aspect of pose the question of what informs your training in terms of CLE or any other aspect. The issue is that ULI has enough data to tell you where advocates need to be trained in whatever field. You can even classify them in terms of appellate courts or the Supreme Court, what has been the challenges of advocates in the Supreme Court, Court of Appeal, High Court. And you get to know where advocates need to be trained. Now, why I'm speaking to that is that it's an informed point of view. Instead of saying, give us money, then we hold a training, you can easily say, this is what we need, and we need to fund a training in this aspect because it speaks to the needs of advocates. I'm speaking specifically about advocates because this forum is specifically about advocates, but there are many aspects about legal analytics that cut across the board. So ULI can inform so many things, like if you want data in form of gender-based violence and you want to know statistics, let me give you an example of talking about on appeal how many cases of gender-based violence have been upheld, overturned, and for what reasons. You'll be able to get statistics with certainty. Leave alone the table research you'll do and say, okay, I think it's 75%. But you'll get that information with complete accuracy because of the aid of things like artificial intelligence and many other things. So I'll speak to something else. Free legal access to the law is not about giving a PDF and I tell you that this is what the Succession Act says. It is much broader internationally than we actually think. The common person has to know the meaning of how the law interacts. Like Council Kulova has said this about the Succession Act and what it totally means. But you take it at another level and say, what did Parliament mean? What was the intention of Parliament? What was the intention of the courts in passing specific decisions? So even how the laws interact has to be explained to the common man for them to understand what they are doing. Thank you very much.
Thank you so much, His Worship, Joel Wegoye. We appreciate that knowledge that you've shared. We also want to repeat and thank you that this is a brain teaser. As you said, next week there will be a CLE training dated on 30th, that is next Friday, 9 a.m. That will be shared with the general membership. And His Worship Joel and his colleagues from the different countries that he has spoken about, South Africa, Tanzania, and South Africa and Kenya, will be joining him to espouse more on ULI. And the take home for today is just for us to know that there is a lot of legal reporting and law reporting. Thank you so much, Your Worship. We appreciate your time. We really appreciate your presence. It has been a discussion ongoing for a long time. We appreciate the judiciary that is also partnering with us. He's representing the judiciary, so we don't take it for granted that he's here with us. Ladies and gentlemen, we're at a session of question and answer. We encourage questions that are coming in for both speakers that are in the house They are contentious issues, but there is always an expert to help us answer those questions. And we got a question or a number of them. We shall start with Council Kulova, if you don't mind. Gerald says, thank you, Mr. Kulova, for the discussion. The new law provides that the consent from family members and, okay, the statement should be, the law provides for consent from family members and an inventory filed. My question is about the inventory. How is it filed, and after how long should an administrator make sure they file it in court? Council, for you to know, some of these questions are from ordinary members because we are speaking to the public, so some of the questions might sound obvious to the lawyers, but also for the benefit of the public, here we go. You could kindly activate the microphone on your left, if it's okay, for you not to move to the front. Thank you.
Thank you. For Gerard, yes, consent of beneficiaries. Yes, and actually the consent of beneficiaries is a creation of the amendment, because before the amendment it was not very clear whether, for example, if an administrator of an estate, if he was going to sell property, he needed again the consent of the beneficiaries, because the argument then was that beneficiaries have gone through this whole process, appointed an administrator or a person who becomes an administrator, then again when they are going to, for example, sell property, they again seek the consent of the beneficiaries. So it was not very clear, and the amendment made it very clear on the consent. Now that is the consent of beneficiaries as regards, for example, disposal of property by administrators. But there is also consent now as regards extension of letters of administration, which are hinted on that court is not going to extend any letters which we believe is a very good innovation, that before court extends the letters, the beneficiaries consent. And the consent is basically that during the period you have been administering this estate, have you been administering it in the best interest of the beneficiaries? Because yes, because an administrator is a trustee, and a trustee basically means that you are not the owner of the property, you are just holding the property on behalf of others. So the idea of consent is based on that this is not your property. Even if an administrator gets registered on the title usually, but they get still registered as administrators. So in other words, it is not their property. It is the property of the beneficiaries. So it is important that if they are going to extend letters of administration, the beneficiaries have a say in it. They can say, no, this man has mismanaged the estate, he has never given us anything, he has not done this or that. So we believe that that is going to bring accountability in administration, which was lacking previously. So that consent of beneficiaries is needed before extension of the letters, especially these people whose letters are going to expire on the 31st. They are going to face the beneficiaries. Okay? It's like a member of parliament facing the electorate. Okay? So it is a very good innovation that is going to bring about accountability. Then inventory. Of course, the law is that every administrator or executor must file an inventory within 6 months of getting the letters. And the Supreme Court has confirmed that. I think there is the case of Abubakar Sebalamu, I think, yes, where the Supreme Court made it very clear that you must file, an administrator must file an inventory within 6 months of getting letters of administration. And usually it is just a report. The administrator is saying that ever since I got letters of administration, I have established the following. One, these are the children of the deceased. These are the properties of the late. And if within 6 months you have distributed, you also mention it. So actually you can even have an inventory and final account depending on the complexity of the estate. So it is a report that you give to court. But also it is an opportunity for you to do what many people are saying, that but some estates have issues. Yes, within 6 months, you can list the beneficiaries, list the properties, but also tell court that ever since I got letters of administration, my hands are tied because we were sued. So there is civil suit number 10 of 2025 in the High Court of Kabale or whatever it is. That is the time to also notify court. Or, ever since I got letters of administration, I have failed to distribute the property because some people have lodged caveats. Because now you can't do your administration because of caveats. And we are trying to have those caveats removed. A very important, that's why it is mandatory. And actually it is even a criminal offense. Of course, not many people know that failure to or neglecting to file an inventory within 6 months is a criminal offense. It has not been, I don't remember anyone being prosecuted, at least to the best of my knowledge, about it. This being a family matter, usually that passes. But it is so serious that the legislator has even deemed it appropriate that they should make it a criminal offense. So within 6 months, you have to file the inventory, and all these grants that are going to expire, majority of them you'll find they have never filed inventories in court. He got letters in 1980, but when you go on the file in court, they have never filed an inventory. So they can't even extend those letters. First of all, now to file an inventory after 6 months, you have to make an application for leave. Apply to court for leave to file an inventory out of time. And many people are filing these applications, those ones I know about. So that is what mainly people need to know about, especially inventory, that if you don't file it within the 6 months, you must first get leave of court to file an inventory. And not filing an inventory is also a ground for revocation of letters. In other words, somebody can go to court, a beneficiary can go to court to revoke the letters just on one ground that no inventory has been filed in court. Such a serious matter that all administrators should take note of. Yes.
Thank you so much. The wisdom with which you dissect these matters shows you're surely grounded. Council, we have a number of questions for you. I hope it is well. If you don't mind taking note of them, I'll read them as they're flowing, and you can help to dissect each and all of them as much as you can. Thank you. The next question goes, anonymous, sorry. I have a question. Are there fees that one has to pay upon application for extension? Are there fees that someone has to pay, that have to be paid upon application for extension? The other question, if it's okay, please, comes from Dana Kasabiti. I'm sorry about the pronunciation. He writes, can a beneficiary who is in court over administration matters move the court to extend the letters of probate? Can a beneficiary who is in court over administration matters move the court to extend the letters of probate as opposed to waiting for the executors to ask for extension? As opposed to waiting for the executors to ask for extension. For clarity, the estate has many beneficiaries who don't agree on anything. For clarity, the estate has many beneficiaries who don't agree on anything. Executors want to get done with the estate, but there are still questions over how they did their job. That's number 2. May I proceed?
Yes.
Thank you. The third is from Doreen. She says, we thank the Parliament for making the amendment to the law. Question, what happens where an administrator got powers many years ago? What happens where an administrator got powers many years ago, e.g., in the 80s or 90s, but has since died without effectively giving the land to its beneficiaries? Does this mean the family will repeat the process and appoint a new administrator? Is it well?
Yes.
You can proceed with those, please.
Yes.
Thank you.
The one of Kasabiti, I think, where a matter is in court. Yes, that is also something that is of concern. That when people are in court, what happens, especially when it comes to issues of now expiry. And to me, actually, this, everything has a good side of it. The Succession Act provides for so many remedies there. It is a very big act, even as we are still just learning it. But there are provisions in the Succession Act that are not utilized. For example, there is what they call limited grants. The letters of administration we are talking about, these ones that are going to expire, usually people are talking about the general grants. That is letters of administration on the estate to deal with everything. Suits, distribution of property, receiving pension and all that. Those are the general grants. But the law also provides for limited grants. And to me, I think this is also a time that people should utilize some of these remedies. Now, for example, when you are in court, and this happens a lot, A has sued B, they are in court, before court makes a decision, B dies. Very common. And now when B dies, because the suit doesn't abate just because somebody has died in most cases, but the practical challenge is A gets. Remember, A is still alive, he had sued B and B has died. Now the challenge that, because now the case can't just proceed with A, there's a legal process to ensure B has a representative. But now the challenge that A gets is that B, naturally people don't want to join a suit that they were not in initially. Even if it is their father, naturally. They don't want to just come in and say, now I'm coming into the shoes of my father who was sued. Naturally, they will drag their feet. The family will drag their feet. A is impatient. He wants the suit determined because he wants his rights determined by court. And what usually A does is to get that, what they call the limited grant, that letters of administration limited to the suit. So it is limited just for purposes of handling that civil suit in court, and that is it. You can't use those letters, for example, to distribute property or do that for the suit. Now, letters of administration limited to the suit are very important, for example, in the scenario that Kasabit was talking about. The beneficiaries in court, letter administration are going to expire, the family is divided, so they may take a year or 2 or 3 years just trying to sort themselves out. So why should the suit stop? So the court appoints what they call an administrator ad litem, who is an administrator pending, for purposes of prosecuting the suit. And at times some people appoint the administrator general to stand in the shoes of the person who has died and the suit was there. And by the way, people just fear for nothing, because when you come in the shoes of that person, some people think that when they lose the case, they're the ones to pay the costs. That is also something that makes people fear. I come into the shoes of B, and then A wins the case, and the court orders that B even pays costs. So the costs and everything is supposed to be paid from B's estate, not me who has stood in the shoes of that dead person. So that is the one that they call letters of administration limited for purposes of the suit. Yes, so many people apply. I know Administrator General has been a subject of many applications. And once court appoints Administrator General, for example, we come to court, complete the suit. If A wins against this, we say you go to the estate and they pay you. If it doesn't have, that is not now the problem of the person who stood in the shoes. Okay, so that is what I wanted to say about that. Limited grants are going to be of help. Where the administrator got powers in the 80s and 90s, but they are dead, is it a new process? Yes, because administrators, when you die, when an administrator dies, the power also dies. It is not inheritable. You can't inherit powers of administration. So when an administrator dies, it means the family just has to get new administrators. The only issue that has been around, which is also a legal debate, is where there are 2 administrators and one dies. Then one is alive. And of course, the law provides that if there are 2 administrators and one dies, all the power vests in the surviving one. But the challenge that we got, which was a practical challenge, was that, for example, if the letters of administration have A and B dies, remember the letters of administration are still mentioning B, and there is nothing that's showing that B is dead. So unless you produce, for example, a death certificate. So Justice Mubiru, in one of the cases, for him, he said, no, actually you need to come to court and they amend the grant, so that they give you now a grant when they have removed B. Because when you go to the bank, for example, and you produce letters of administration and they ask you where is B, and you say he's dead, the banks usually are reluctant to entertain such an application where one of the applicants is dead, but the letters are showing that he's alive. Even if you start bringing a death certificate. So the courts were saying that you go to court and they strike out that dead, they give you a fresh grant, which has the same number as the old one, but now bearing only A. Of course, discussions have been ongoing, especially in the legal fraternity, that is leading to case backlog. How about if the administrators are 5? One dies this month, you go to court, they remove him, they remain 4. Unfortunately, within 2 weeks, another one dies. You go to court, they remove him, they put 3. Unfortunately, in 1 week, another one dies. So now the people were saying, of course it is a speculative, but they were saying the practicability of it, especially when the administrators are many. So that one, I think the issue is that when all of them die, or it is one and has died, then it is a new process. I think those were the 2 questions.
Yes, there are others here, if you don't mind.
Yeah.
Jurua Derek, my little brother. How long should it take for the administrator to hand over properties to the beneficiary? Is there a timeline? How long should it take for the administrator to hand over properties to the beneficiary? Is there a timeline? Number 2, Nampeo Winnie Lillian asks, but states, to council, when do we file for extension? That's the question. When do we file for the extension? Last night, it is said, Senior Counsel Mutavingwa, one of the advocates, stated that the practice in court is that you file application before expiry, and the deadline finds it thereafter 31st. You should apply for fresh letters. And now council has told us we wait for expiry, and that is the position of Administrator General's office. Kindly clarify on that. It's a little ambiguous. I hope
yes,
it has made sense. Is it okay?
Yes, I think I will start with that one.
Please.
Of course, whenever there is a new law and it is being tested, there are many approaches. And we have seen it even with the judges. But I'm sure as we go ahead, these positions are going to be refined. It is usually understandable when a law, an amendment like this new one, is being tested. So it is true there are now differing opinions from the courts, and but in my view they are not even fatal, because even if you apply before extension or after extension, both options are available, either before or after. Because actually the real argument before, where the people were saying that how do you extend something that has expired? It looks a logical, or sounds a logical argument, but it is actually, the law allows it. Actually, I was looking at the Interpretation Act, and it allows court to extend time for doing something even if that time has expired. It is in the Interpretation Act. So it is not true that you, after expiry, you don't do that. But also, if you put in an application before expiry, in most cases it is going to be determined when the grant is already expired anyway. We all know. For example, if you put in an application today, it is not very possible that by 31st the court would have had that application. By the time the court hears it, actually the grant would have expired. So in both cases, in my view, there shouldn't even be confusion. Even after extension, I mean even after expiry, court can extend that time that has been provided. Then the other was on how long does it take for an administrator to hand over property. Yes, now Parliament has now settled this. Before that it was not clear. People had estates for eternity. But now they're saying you should do it in 2 years. And the law is saying that if you fail to do it in 2 years, come to us and tell us why we should give you more time. In my view now, the position is becoming clearer. It is now 2 years. Finish up the estate. But if you think that the 2 years are not, bring reasons why. Have you been doing a good job? Do the beneficiaries even approve of you, or you have changed? Okay? So, to me, and I know of a court that has extended a grant for 7 years. So now, when you look at such a decision of court, extending a grant for 7 years, you realize that the intention for the 2 years and the 3 years was to awaken people. In other words, you can go to court and court is like, yeah, the evidence you have brought shows that you might need now more 5 years. Yes, I think it is reasonable under the circumstance of your state that you need 5 years. Or, since you are remaining with only one property to dispose of, we are giving you 1 year. So they are giving court discretion. It can give you 7 years, it can give you... The law has not even said that court is limited, that you should only give for this period. No, it means it's going to look at the application. Why have you failed? Okay? Some estates, beneficiaries are just stubborn. I know of an estate where beneficiaries were insisting that a 100 by 100 plot be divided amongst themselves, and there were 12. You know, in succession law, you find very illogical things, even by educated beneficiaries, highly educated, but you say, but now here. He said, no sell. We are not selling this property. Give me my plot, give me my share. But we all know that, for example, you cannot get a land title for land that is less than 50 by 100. Titles are now issued for plots that are 50 by 100 and above. Anything below that now, you can't get a title. Now, these 12, if they are to divide their 100 by 100, how big a piece? And it took 8 years. So now that's why these days when it comes to sell, much as beneficiaries must consent, the parliament said, or the amendment, they said that if they refuse, if somebody withholds the consent to sell, for example, court can order a sale even without the consent of the beneficiaries. So, if you go to court and, for example, the reason is that I've failed to distribute this 100 by 100 because beneficiaries don't want to sell, they want to divide it, and it is impracticable to divide it. So court there can even order for a sale of the property, and there might even be no need for extension of the letters of administration. Yes.
Thank you so much for the wisdom. Clearly, your 14 years experience in the AG's office is evident. We thank you for the time and the answers. Council, you forgot to address the question to do with the fees to be paid for extension.
Oh, yes.
That was number one. Then there's a last one for your attention, please. It reads from AJ Luaga. AJ Luaga says, or asks, does an administrator lose his or her legal preserve of being a legal representative of the deceased upon expiry of the letters under the amendment? Does an administrator lose his or her legal preserve of being a legal representative of the deceased upon expiry of the letters under the amendment? Does he or she still have the right to sue and defend suits for estate recovery? That was the last question.
Yes. On the fees, I think the fees are the ones because the extension is by an application. Since the law doesn't provide a specific procedure, it is taken that it is a notice of motion. And the fees that you pay on the ordinary notice of motion, I think it should be 6,000. That is what you pay on the application, filing of the application. So the normal fees that you pay, court fees. Then effect of expiry, yes, once it has expired, it means now you have no legal authority. You have no legal authority. For example, you can't now transfer property of a deceased person when the letters have expired. When there are suits, if the suit was instituted before expiry, in my view, like I said earlier, that suit remains. It is now for purposes of parties getting an administrator for further prosecution of the same. But you cannot now institute fresh ones because now you don't have any legal authority upon expiry. So the expiry has that effect. There's things that were done when you still had the authority, and for example, a suit instituted, you can now get letters of administration limited for prosecuting the suit, but you can't now institute a new fresh suit because you have now no letters. So that is the difference I would see in those two.
Thank you so much. Ladies and gentlemen that are physically present, could we give a round of applause for counsel for doing justice to those questions? We really appreciate that wisdom shared. The next batch of questions are going to His Worship, Joel Wegoye, who has been helping us unpack the issue of Yuli. And the first question, if you don't mind taking them. Yuli has done, this is from Andrew A. Yuli has done a great job in advancing access to information, which is a right under Article 41. However, most Ugandans are unable to access the internet, or they don't even have smartphones. Does the law reporting in judiciary have plans of circulating hard copies or rather untranslated versions of laws to the public, especially those upcountry? I'll repeat. Does the law reporting in judiciary have plans of circulating hard copies and translated versions of laws to the public, especially those upcountry? That's number one. Then Georgina says, how are you going to address the issue, I think you handled this one, of being upcountry and no access to internet, which I think is sufficient for you. Maybe you can just top it up. Maybe you can explain it a little more to the people. The other reads, it seems the website has some accessibility issues these days. Would appreciate some clarity on what is going on. This is from Kenneth. You can take those if it's okay for now.
Before His Worship comes, I had a question for Assistant Administrator General. For the sake of the public, especially those who got the letters so many years ago, because we heard from him saying that you come to court, but maybe if you can support them understand which courts to go to in different districts, where do they go to apply for extension or to get any information? And do we have, let's say, a toll-free line where someone can call to ask for information rather than coming to court physically? Thank you.
Okay, maybe just quickly, that is important because the court we are talking about here is the court that issued the letters. The court that issued the letters of administration is the one that can extend them. So if you got it from magistrate court in Rukungiri, so it would be the magistrate court in Rukungiri or if it is the family division, it is the family division. So in other words, you look at the court that is mentioned on the letters of administration, and that is the very court that you go to extend or renew the letters. On the toll free, I don't know whether you meant for, is it for the courts or the number? Okay, maybe I'll share with you the numbers, which you can share with the general public after.
Thank you so much, Your Worship.
Yes, I'll address the first question concerning circulating hard copies or translated versions of the law. Now, you have to realize that there are entities that are mandated with specific tasks in this country, and I believe it is the Uganda Law Reform Commission mandated with this task. You all are aware that I think because of rationalization, certain things are going on within government, and we should also be aware about that when we're talking about mandates for specific government entities. For this specific question, it is supposed to be the Uganda Law Reform Commission. But I am also aware on the future of law reporting like is happening in Tanzania. Right now, AI can allow the system to read to you the law or the cases or explain to you the cases in the local language. Because right now in Tanzania, what is happening is that Tanzli, because Kiswahili is majorly the spoken language in entire Tanzania plus Zanzibar, when a lay person who does not speak English goes on Tanzli, it is able to interpret and speak to them in the language, in Kiswahili. So it is simplified. I think with time we shall get to that point. Then the issue of the internet, like I told you earlier, right now we are introducing concepts like pocket law, street law, whereby even the lawyers up country will be able to access the materials on a platform like Yuli without the requirement of the internet. What happens in those kinds of applications is that when I walk through a Wi-Fi place that has internet and my phone is connected, my phone will update itself automatically. So when I get out of that zone, I'll have the information for that particular time. Let me say an example like Yuli. If I pass through here, even the case I've updated today morning, you'll have it on your phone. And you won't need internet to access it when you're out of that zone. That means if you're up country even for 2 weeks without internet, you will be able to access all the legislation cases, gazettes, and whatever is uploaded on Yuli at the particular time you pass through the internet zone. Then we were aware of the accessibility issues being raised by the general public. But I want to inform them that it wasn't an issue concerning Yuli. It was more about our area local network, maybe the browser you're using, and maybe many other things. So Yuli as a system was working and is working full time. Because many members called us and we could access the system with them and they could get it. But then you also have to be aware, as a platform we have gone through significant transformation. And many features that members knew before have changed places. For example, during that week, you realize that the icon on your phone would automatically say download on the right-hand side. But it was changed that if you're accessing Yuli from your mobile device, there are 3 dots that will be besides. One will allow you to share the document, one will allow you to download the document. And so when people would see those 3 dots, they would not know what they are for. So you have to know that the system is changing constantly. But the training organized for 30th will address all these issues, because we shall be able to go through the platform with all members, whether the society or the public will attend. We shall be able to explain with certainty what features are there and what they are to watch out for, and how they can effectively navigate the system. Thank you very much.
Thank you so much, Council. We appreciate. The other 2 questions read, one from Agnes. how can Yuli support legal research and scholarship in Uganda? How can Yuli support legal research and scholarship in Uganda? The other from Aaron states, how does Yuli fit into the broader landscape of legal information and access to justice initiatives in Uganda? How does Yuli fit into the broader landscape of legal information and access to justice initiatives in Uganda? And a very interesting one about the challenges that Yuli might face in providing access to legal information is coming from Awan Alituvera Justice. What are some of the challenges challenges that Yuli might face in providing access to legal information, if you may? Thank you.
I'll speak to legal research and scholarship. I'll speak concerning a study that was made concerning how much money entities get from publishing legal research, like legislations, and all other legal materials, law journals. I know the ULS produces a journal, but the studies showed that there is no entity that recovers any money from publishing legal research. That means the biggest benefit of any entity doing law reporting is in providing access to the public of their materials. In terms of, like I told you earlier, Yuli has a user base of about 200,000 users per month, which would mean that if a journal you've kept here is being read by 200,000 people, it will be cited in different legal materials. And there's so much benefit in that, in giving your research credibility and many other things. So I believe the biggest benefit is through publishing journals, articles on such platforms as Yuli. Definitely, Yuli has the capacity to hold any article, any book. And as you can realize currently, the judiciary bench books are provided for on Yuli. And they are interlinked. If you look at certain court cases that quote the judicial bench books, you'll find that we cross-reference them. And you can get to know that this is where it comes from. Now, like I told you earlier, the future is in partnerships. Definitely, to be able to support scholarship, there will have to be criteria under which approvals will have to be got for such materials to appear on such sites like Yuli. But the conversation can start, like a discussion can start between the Law Society and the judiciary on whether or not the journals should be published on Yuli. Because like I told you, if I asked you, from selling the journals, how much do you get? You'll find that probably they use more money to publish than they get from selling the journals. That means the best benefit would be, let us market our advocates who write these journals by publishing their journals on platforms as Yuli and many others. So through that, you'll be able to support research and scholarship, as they have said. Then I'll go to the challenges before I answer the second question. The challenges of legal information. Now, I think the biggest challenge is remaining competitive. Because like I told you, you wake up today and you realize something is being done. Like I've told you, something like street law started in Tanzania more than 6 months ago. I am aware that Kenya and Rwanda are also adopting the same method. So the issues, as a country, we have to be alive to such instances and we have to move at par. One thing I'll tell you for sure, the judiciary has invested so much in technological innovations. Because as you may be aware that Yuli is not used majorly because the judicial officers are a small number. But the biggest users are Yuli are maybe the general public and the advocates. So there is so much investment going on around technology. But the biggest challenge right now in this day and age, I don't think is about the technology advancements and anything else. It's more about data collection. You find that technology has found us at a time whereby we are lacking data in terms of, speaking to Yuli, you'll find that specifically you're lacking cases for certain courts, you're lacking legislations, you're lacking Hansards, and you're lacking so many things. But if I could state this here, the judiciary has a program under which the Yuli team and in conjunction with specific registry we are assigned to, we collect decisions from all these registries. And currently we register, we upload about 3,500 cases per quarter. Now that is significant. I can speak with certainty that for the Supreme Court, I would have said 100%, but we have 99% of the decisions of the Supreme Court. We have so far done 2 phases of the Court of Appeal, because I believe it probably could be the biggest registry we have in the country. And I'm sure with the last phase that we may go back, we shall be able to complete, and we say we confidently have all cases that were passed in the Court of Appeal. Now, like I told you, currently on Yuli you can tell whether the case has been overturned or upheld, because we have started interlinking cases from as low as the tribunals to the Supreme Court, so that you can able to track a case that has been overturned before people would come and quote cases that have been overturned. But currently it's a thing of the past. If you check on the Supreme Court, most of the cases have been interlinked. We track all the cases as far back as High Court decisions, as far back as the 80s, the 90s, and we interlink them with the Court of Appeal plus the Supreme Court decisions. So that to me is the biggest challenge, information, because the other challenges of finances and every other things can be dealt with in due course and in due time. But the challenges of information, but as I'm telling you right now, there are already measures to be able to curb these challenges. And like I have told you right now, I don't think you need another platform for research. Yes, you can go to these other lists and everything to do a comparative analysis. But for our local cases and legislations, we have a fully fledged database on Yuli. And there's a deliberate intention to make sure it is so. Definitely there is also a challenge of technical capacity. Because yes, we say we are law reporters, and many of us call us ourselves as such. But what qualifies you to call you as that? Is it because you upload a summary or a fly note or whatever? You get it. It is, I believe, from my travels and experience, it is far much bigger than that. I believe more than ever that law reporting is more of a calling than anything else, because it is a department whereby you have to love what you're doing for it to be done. It won't have a chain of procurement or anything else, but it has to come from the heart. So you have to do it. So you have to make sure you have the technical capacity to do it. Like, I'm sure that the Yuli team undertook a training on legislative drafting. And currently, we do our legislative updates in Uganda. So both financially, capacity building and everything, as a team we are trying to make sure we are at par with everything we are doing. So yes, the challenges are there, but I can say the deliberate effort to make sure we are even better and we are competitive as far as technology is concerned. Thank you very much. Then I'll go to the second question of how does Yuli, just repeat it. The second question, broader access. On law reporting. How does Yuli fit into the broader
Yes, how does Yuli fit into the broader landscape of legal information and access to justice initiatives in Uganda?
Yes. Yuli is not only a tool for raising legal awareness, it's also a tool for judicial accountability and transparency. Why do I say so? when a judgment is published, it's a public document. You get to read what the judgment entails, which means in you reading that judgment, it creates a level of transparency as far as what the judiciary is doing, and they're accountable to the public. But also you have to be aware that it also opens us to criticism. The judgments that have come through, and the public has had opinions about them. Whether they are right or wrong, that's a subject for another day. But as you can see, it is not only saying that this is this. It is more about a platform for judicial transparency, accountability, but that only supplements the overall objective of free access to legal information and also empowering the public with legal knowledge.
Thank you so much, Your Worship. Ladies and gentlemen, a round of applause for His Worship for doing justice to those questions. Ladies and gentlemen, we are still proceeding. It's a question and answer time. We were joined by the Honorable Vice President of the Uganda Law Society, who has been on a trail of events and has honored to grace this occasion today. We would like to welcome the Honorable Vice President of the Uganda Law Society, Advocate Anthony Asimwe. We're so glad to have you around. In your absence, our discussions for today are Succession Law, Understanding Key Amendments in the Succession or an Amendment Act 2022, and Legal Tech, Navigating ULI and the Future of Law Reporting. We have two able advocates who are giving us wisdom, off the cuff comments as well as questions, and we are so thankful that you're also here to aid in the discussions. We shall be hearing from the council representatives very shortly. The topics are exciting, the questions are flowing. It is an interesting day for us as Uganda Law Society. We are so honored to be interacting with the judiciary in regard to the JTI, Judicial Training Institute, represented by His Worship Joel Wegoye, who has come in very, very big shoes to break down legal reporting or legal information. We thank you. But there is a hotter topic, and Council Kulova, I hope the seat is not so hot. We have more questions. We had earlier on thought that we had gone through them all, but people are very excited about the question, especially about the expiry. As you said, your intention or the intention of the amendments were to wake people up. So members are awake, those online and those physical. We have another question for you, if you don't mind, please. It reads, good afternoon, colleagues. It comes from one of the WhatsApp groups that are also following legal related. How do I go about a situation where one of the appointed executors to a will is not cooperative in as far as arrangements are made to get letters of probate? The question reads, how do I go about a situation where one of the appointed executors to a will is not cooperative in as far as the arrangements are made to get letters of probate? Can one ignore that one person who is not cooperative? Can one ignore that one person who is not cooperative and let cooperative ones get the letter of probate? It's something I think you had hinted upon. You could as well just shed a little light. That's for somebody I think who wasn't here with us. Rita Nandera asks, why is the law expiring to senior state why is the law expiring? I think it's really the issue of expiry. It wasn't clear. I hope it can come home to you. Finally, there's a question from one Barbara Salome. She has enjoyed it. She has learnt more, and she's very thankful. The question reads, and can consent of beneficiaries for extension of letters of administration be short recorded videos? for those who are scattered in different locations and can't travel to have written consent. Does it make sense? Yes, those are what we have gathered so far. Thank you so much, members online and those physical. We are still welcoming those questions. I hope that's okay. Council, please.
Yes, the first one was where one of the appointed executors in a will. I think that, Robert, that is actually different from what I had explained, because when it comes to letters of administration and people are not cooperating, but this one that's saying where executors are appointed in a will, but they don't, one is not cooperating. Because where there is a valid will and it appoints executors, it means that you don't go through the Office of Administrator General. Is it to sit in a family meeting? The law respects the wishes of a deceased person to a very high degree. So if somebody appoints someone or people in a will to be executors of the will, the family members can't be seen to be sitting again also in a meeting saying, you see, for us we want so and so. The wishes of the deceased must be given maximum respect. So the law allows that where you have appointed more than one executor, the law allows even one to apply for probate. It is not a must that they must apply for probate together. It is something that is some little balance there to make. It is only when they have been appointed that they must act together. But before appointment, let's say one doesn't want to apply, one can apply. If there are two and one doesn't, or there are three and two are cooperating, one is not cooperating, the law allows two to apply. So I wanted just that to make clear. Why expiry? Yes, I started with this one. The whole purpose of letters of administration expiring, one was to awaken a sleeping public of administrators who have been asleep for decades. They have not either, they have never distributed the estate, or they have distributed the estate to themselves without distributing to other beneficiaries, so they are fearing accountability. Or just out of ignorance, people think that when you get letter administration, you just go and sit back. So basically not understanding the roles of an administrator. So the expiry was to awaken people. And in my view, that awakening is very, very apparent as we talk now. And to me, that's why I was saying to me that the law has worked. It can be a debate, and laws are made to serve man. It can be a debate that after this, the general public, through giving their views, can say, no, let's give it 5 years and not 2 years. It is important to first test this one. I'm always saying that let's first test this. Then if we believe that maybe it should be longer, laws can always be amended. But let's test this, especially people who have been administrators for a very long time. Really, there must be accountability. And this law on expiry is actually aimed at getting accountability from administrators. You got letters in 2000, yes. What have you done? You realize that the property of the deceased is still in the deceased's name. So what was the purpose of us giving you letters of administration? Give us a report of what you have done. Secondly, the beneficiaries, have you been handling the beneficiaries well? You are just a trustee. It is not your property. You are a trustee. So, what is the view of the beneficiaries whom you were administering the estate on behalf of? What are they saying? What report do they have about you as an administrator? Should we really extend it? A letter that was issued to you in 2000, should we extend it? Okay? Then there are those who will come with very genuine reasons. We have been in court for the last 10 years. So I couldn't do anything with this estate. Evidence is provided to court, and court gives an extension based on that. Like I said, I have seen extensions for 7 years. So in other words, they gave you 2, but court now believes that the circumstances require more than 5 or 10 years. So it is more of awakening a sleeping public. The formal mode of consent, can it be audio? Yes, the family division, and I think His Worship, his topic now ties into ours. Administration of estates is one area where now technology is very important. People are in Germany, people are in Sweden, they have estates here in Uganda. And you find a Ugandan in German, but he's saying, I want to be part of administration. And the family thinks, yes, he's the best suited person to administer that estate. So if he's in German and the matter is coming up for identification, for example, in the family division, previously that man or woman had to put in an air ticket and fly. And actually, some people declined administration just on that ground that really, I cannot. Because you can even put in a ticket, come, and then the matter is adjourned. The judge is not there. Adjourned up to August. So you have to again put in a ticket, go back, and then come back or wait. And so it became, now, the good thing is the family division has adopted identification virtually. So even if a beneficiary is in the diaspora, they can actually attend court proceedings virtually. It is something that we should encourage so that it is fully embraced by all courts, the issue of, so that a beneficiary can give a consent. Even in the Administrator General's office, I had a meeting, I think last week or something, and people were all over the world consenting. Of course, as His Worship, they will tell you that comes with its own shortcomings, but there is no way we can run away from technology. So if you are on Zoom, you want to be very clear and certain that the person you are interacting with is actually the right person. So we are times in addition to the Zoom meeting, we tell them to now send us scanned copies of their identification documents, maybe a passport. If they have a national ID, they send scanned copies so that we have that record of Zoom, but also sure that the person we were talking with is the right person. The beneficiaries usually confirm when the person appears on the screen that yes, that is our brother. So that we are not interacting with a non-beneficiary of the estate. So that one was on the formal mode of consent. But the traditional mode is a written consent. Yes.
Thank you, and thank you once again. Ladies and gentlemen, we are excited and grateful to you for continuing to be with us. Clearly, the work of the Uganda Law Society, bringing together JTI in form of ULI and the AG, as has just been said, is now getting easier. We would like to encourage the public and the general membership to be more articulate as well as interested in matters touching both legal reporting and succession law, because they are also personal. We have come to a close of the question and answer session. We would like to thank you. We would like to request that we give a round of applause to our speakers. Thank you once again for your able discussions. We ask that the Lord bless you. Honorable Vice President and Honorable Treasurer, once again, we thank you for being with us. With the blessing of the President of Uganda Law Society, who is out on official duty, we thank you for the continued blessing. We would like to take this opportunity to welcome the Honorable Treasurer to give us a few remarks, who will in turn welcome the Honorable Vice President to give us closing remarks and anything else that shall be coming from Council. Thank you, ladies and gentlemen. The Honorable Treasurer of the Uganda Law Society, Advocate Arthur Isiko. Thank you.
Thank you, Master of Ceremony. Good afternoon, everyone. Let me take this juncture to, first of all, I thank our visitors who have spared time to attend this wonderful session. The advocates, both online and those who are physically present with us, our invited guests, Your Worship, Wegoye, Joel, thank you so much for joining this panel today. Mr. Kulova, Mr. Henry Kulova, thank you so much for sharing those wonderful insights that touch a very sensitive topic. It is a personal topic. When you look at administrative issues, they're always personal. I believe everyone has so many questions to ask and probably seek answers. So thank you so much for that. I will make a few remarks before I invite in the Honorable Vice President, who has been on official duties, representing us at various forums that have been ongoing. I also send greetings, by the way, from the President himself, like it has been clearly stipulated by the MC. He's away on official duties, and also greetings from other council members who are always online and listening and following whatever transpires. Unfortunately, we began a week on a sad note where we lost one of our own, a colleague of ours, a senior advocate, John Baptist Kakoza. I would request that we take a moment of silence to recognize the efforts of this senior advocate. May his soul rest in eternal peace. Yes, I will begin with making a few remarks, especially on issues pertaining to the welfare of advocates and also the members of the public. Of recent, we have been seeing arrests. We have been seeing arrests of lawyers by unknown members of the public. One of them is a person who once contested to become a member of parliament in Iganga. This matter has, of course, been followed by the Vice President, who was trying and has actually ensured that this member actually gets the due justice. But we as Uganda Law Society, we call upon security agencies. We want to remind the security agencies that in the process of doing your duty, please try to align with the law. Honorable Mao was here and he said that what is so hard for a security operative to introduce himself. The advocate that was arrested is not a terrorist, is not a murderer, but the method in which he was actually arrested and then later on detained by the unknown security operatives as of today leaves so many questions, leaves so many unanswered theses that need to be really understood by the wananchi. So we as Uganda Law Society, we condemn and we encourage the security agencies to really comply with the law. If you are detaining someone, please detain him in a recognized place that is known by either his relatives or his advocate, so that it doesn't become an issue of alarm. These things are becoming issues of alarm because people are being detained in unknown places. Up to now, no one knew where Mr. Mudiobole was being detained. So that is really uncalled for. And like I've said, we encourage the security operatives to actually keep and maintain law and order. In respect to the UPDF Act, the Vice President of Uganda Law Society has always expounded on this point. But of course, as the Treasurer, I would also want to further clarify that we believe the UPDF Act was forced onto and is being forced onto Ugandans. If you look at the manner in which actually it was passed, it leaves so many questions, it leaves so many holes. We received a letter just 10 minutes to the consultative meeting where Uganda Law Society was being invited to make contributions towards the passing of the law. Yeah, so that alone clearly shows you that the manner in which this act was really passed was fast-tracked without actually consulting the key stakeholders. Uganda Law Society, the role of Uganda Law Society is to ensure that we advise government on sensitive matters of the law. If you clearly look at Section 3 of the Uganda Law Society Act, it is our mandate to ensure that we advise government. So the manner in which the government of Uganda was calling for that advice from Uganda Law Society was really having so many question marks. You can't call someone to a meeting 10 minutes asking him to probably give you advice on a document that is more than 100 pages. So, as Uganda Law Society, we maintain that this act is unconstitutional. It is in violation of the Supreme Court decision in Kabaziguruka that actually made it unlawful, made it unconstitutional to try civilians in military courts of law. Yes, we understand that probably there may be an abuse of military attire by some individuals of the society, but that also cuts across other entities. Yeah, today it is a military attire, but there are so many other entities where probably people are taking advantage and are abusing those various entities. So should all those other entities also probably government come up with laws saying that probably also in this area, let's say if someone impersonates a surveyor, then probably should also be handled by the surveyors. Yeah, this is something that we believe all matters, especially pertaining civilians, should be handled by the civil courts of law. This should not be a coup on the judiciary. In fact, we see this as a coup. This is a real coup on the judiciary, taking away the actual responsibility of the judiciary, which is to deliver justice. Yeah, listen to complaints and deliver justice, especially on issues concerning civilians. So that is our stand, and we shall maintain that stand. In as far as the activities that are being done by Uganda Law Society, this is to update and inform members that on Saturday, the 24th of May, Uganda Law Society, the Eastern Bar, headed by our council member, Mr. Eguru, Mr. Nangulu, Edmund, we shall be conducting a prison visit to Soroti Prison. Your Worship, we had a prison visit in Mbale, and one of the things that we discovered that there are so many inmates there who have been committed, remanded for more than others 3 years. So some few, it's now around 13 years. and they have never been actually committed to the High Court. Some have just been remanded, and they've never been remanded, brought back to court probably to be committed to the High Court. Those are some of the issues that we are seeing, especially in the areas, the far-reaching areas of Eastern region, in Bali in particular. And we are continuing with more discoveries. We are heading to Soroti. We believe that such a visit will enable us probably identify gaps and address such gaps to the relevant authorities. Good enough, the senior judicial officer, Mr. Wegoye, Joel is here. We addressed a letter to the chief registrar. We addressed the letter still to all the top tier of the judiciary, informing them about these anomalies. So we request and we pray that there is speedy trial, especially for all inmates, not only in Mbale or other areas where we shall be going, but all the citizens of this country, because delay defeats justice. Delay defeats justice. And that is where we have always encouraged the High Court, Civil Division, that we filed an application to set aside the orders that were granted, saying that the president of the Uganda Law Society should be in prison for 2 years. But up to date, that matter has never been fixed. We believe not fixing is affecting the rights of a Ugandan. It is affecting the rights of an advocate. It's affecting the rights of the president of the Uganda Law Society. So we pray, and we do believe that you're hearing that. Please expedite not only the matter of the president, but even other court cases. I believe sometimes advocates don't follow up their cases, but for those who really follow up their cases, they deserve to be given hearing dates. And I think we thank the judiciary of the case of Mudi Obole, where we are applying for habeas corpus to ensure that he's brought to court, was expeditiously given a date by the judiciary. We want to thank it for actually taking that active role in ensuring that a date was given. And indeed, we believe that advocate will receive the much anticipated justice. Talking about the topics that have been actually talked on by our panelists, thank you so much for our dear panelists. Thank you so much for the knowledge that you have given to not only the advocates, but even to the members who are listening in. I received communications from Cuba, Bangladesh, and Moldova last week that Mr. Henry, the information that you are giving out was really insightful, and they were calling upon for more further seminars and symposiums where you can actually come back, and I think that was the spirit in which you had even to bring him again to further elaborate on such issues. So we thank you, and that is one of the key areas where we, as the Radical Nuba, we are really putting emphasis. That is decolonization. Some of the principles that he has actually talked about were colonial, where you are denying a girl child inheritance. Girl child was being denied inheritance. Even up to date, some ladies and some girls up country and even here amongst us are being denied an opportunity to benefit from the work and efforts of their families. That is really unfair. I believe just like Mr. Henry has clearly elaborated, we are all equal before the law, regardless of our gender, male or female. We deserve to really be partake in part of the sweat of our parents. The judiciary, we thank you for that, the effort that you have always done. ULI is not a Uganda Law Information Institute. I think lawyers are familiar with the word ULI, but the public may not be familiar. ULI is it's like an app or a website where you can get all legal information, cases that were decided yesterday on that platform, that website. If you want to understand laws concerning media, especially the media people who are here, You just to go and type rights of my rights as a journalist. They are going to give you decided cases as latest as yesterday. They have really equipped ULI with the sophisticated research protocols where you can even understand that a case has been nullified, a case has been upheld. Initially, it was incumbent upon the lawyer to actually do further research and confirm, is the case that I am reading, was it upheld, has it been nullified? You could actually be embarrassed for the lawyers who are out there. You research a case, only to go to court and they're telling you this case has been nullified. But with the help of the judiciary, spearheaded by our own, His Worship Joel Ogoye, he has actually improved ULI. And I think we need to clap and thank him for that initiative. In fact, that is part of our 4Ds also, the digitalization mode. And we shall do whatever it takes as council to ensure that we can actually have meaningful partnership, to ensure that the advocates, who are actually one of the biggest beneficiaries of ULI, can actually benefit from even those other packages that you have labored to actually explain. So without taking much of your time, I would want to welcome the Vice President of Uganda Law Society to actually make the conclusive remarks in regards to this seminar. Please, let's invite the Vice President.
Thank you, Governor Bank of VLS. That's how we refer to him. Our Treasurer. Your Worship, Joel Wegoe, our distinguished guest, Mr. Henry Kulova, members online, those who are here physically, secretary staff present, and members of the media. I do appreciate your presence here for sticking with us. My duty here really is to pass a vote of thanks as I close. I will apologize for coming in the middle of the session. I would have loved to be here right from the beginning, but as you're aware, we have quite a number of activities ongoing. Just before I came here, I had to be part of 2 different engagements. Right now we have an employment law conference ongoing in conjunction, which is being organized by the Uganda Law Society, Radical New Bar, in conjunction with Signum Advocates, and the Human Resource Managers of Uganda Association at Mistil, which is a 2-day event where we're engaging together with the industrial court and other stakeholders in the field of employment and work-related aspects. Then we also had the launch of the Muslim Arbitration and Mediation Center Uganda at Hotel Africana. This is where some members of the bar have become creative in trying to find ways of resolving issues of access to justice through mediation and arbitration, where we also had 2 justices of the Supreme Court, Justice Chibedi and Justice Chibita. That is why I had to be there to represent the Radical New Bar before joining the team here. Not that what is being discussed here is not important, it wasn't important, but we have to have presence everywhere because these are all important aspects. Now, my thanks specifically, my vote of thanks goes to JTI and my colleague, my friend, Joel Ogoye. Most of you might not know we have a history. He actually happens to be my classmate, and I'm proudly associated with him. Usually, when we have these engagements, the reason we started this Rnblive, where we engage with the members of the public, the members of the bar, and other stakeholders, is to reduce the knowledge gap and to have candid discussions where most questions are answered, people get information, and also I'm sure Robert must have been emphasizing our mandate under the ULS Act, Section 3, because it is our mandate, a statutory mandate, to make sure that we are relevant to the members of the public. We guide and advise on matters touching the law and auxiliary to the law. And we are the only hope for the members of the public. All of us in the JLO sector or any other service provision, we aim at providing services to the members of the public. And if we do not give them an opportunity to engage, we do not hear from them, we do not listen from them, we'll be wasting our time. We'll be doing things that only benefit us. But particularly for JTI and Joel, I'll extend thanks, and also to the institution itself. It is not easy to have, you leave your place, your office, and come here to be part of this. For the young lawyers who are online and in the field may not know how hard it was during early years in law school, where we had to fight for those few law reports from the library. And some of them you'd go and find someone has removed a page. As you're reading a law report, a page is missing, or it is spoiled, it is badly, everyone keeps writing on it, you can hardly read. And those are the days that would give us those big reading lists. You joined law school for the first time, they give you a reading list with over 1,000 cases. Then you go in the library, there used to be a cage down there. The law report you're looking for, because it is the first case on the reading list, everyone is fighting for it. They've taken it, you cannot access it. And also happen to be a teacher. I do teach at the Law Development Center. But I can assure you the developments that are coming up, being brought by Yuli, and the updates are really resourceful. They are simplifying work. At some point, I'm forced to say that Yuli is making lawyers lazy. Not like our times where you had to hustle to get to do this research and read. And there are scenarios where you'd find people quoting just, that case summary. But when you ask about the principle that is embedded in the case, they know nothing, they have no idea. Sometimes it's not even applicable. They just quote the top. But Yuli is really doing a great job with digitalization and the fact that the population is growing, and that is where we're headed. We do appreciate, and it's really a resource for members of the bar and also members of the public, because anyone can access Yuli. At any one point, you can access any authority you want. What I implore the members to do is please make use of this resource that we have, including members of the bench. We've had scenarios, I'm sorry to say, where you find some members of the bench citing old law cases that have been, someone cites a case, a High Court decision, when there's a Supreme Court decision overturning it, and this is a High Court judge. But I'm glad, like you've had an explanation from His Worship, that at least now they link, there's a High Court decision that has been challenged in the Court of Appeal, in the Supreme Court. It is linked so that, that problem is solved, because in most cases, as we rush through research, as long as it is our duty to also guide court, not to mislead court, you end up quoting an old case, then the judicial office also has not read, or has not bothered to research, will also cite the same. And we disorganize, we mislead the public. So this is a very good initiative. And what I can say is that as the Radical New Bar, we pledge to support, to work closely with JTI, to work with your team, to make sure we keep, bringing this knowledge closer to the people. And any other developments, any other innovations that you may have, please feel free to reach out to the Radical New Bar. We are open to working with you. And this is not just for the benefit of the judicial JTI, but for the benefit of the members and the community generally in the area of improving access to justice. Again, in a special way, allow me to thank the Office of the Administrator General, and specifically my colleague Henry Kulova, with whom we teach at the Law Development Center. He's always a resource. As you may recall, I think even last week we had him here. It is not easy to have someone being this committed to the cause to always show up or turn up whenever they are called upon. Like I said earlier, in this area of access to justice, there are so many stakeholders who have a role to play. Every person has to play their role. The only challenge you have is that there are people who are in some of these offices, public offices, where they're supposed to do more than that, but their only focus is sitting in office, doing what they are doing, and receive their salary and go home. So this is a commitment we do not take for granted. I feel so bad that we do not have members of the judiciary, especially from the family division, other courts where they practice in this area on a daily basis. Last week, if you remember, in the remarks of Henry, he made something that we all laughed about. He made a comment that we all laughed about when he said that if you're passing a law in Parliament where they're talking about maybe companies, a one-man company or one person conducting a meeting, a one-member company, one member conducting a meeting and passing a resolution, very few people will be interested in it because of the nature. That is because of the nature of the community and society we have. But if it is anything to do with family, land, then there's public discourse. The public is interested because that is where most people have issues. That is where, because of the nature of the population we have, the biggest part of the population we have in Uganda, it's either family disputes or land disputes. And when you combine administration of estates and family matters, it does not, that's the most sensitive area. That's why you find in practice families are being torn apart. That's why you find disputes arising, even between twins. People are twins. I know they can dispute over certain other things, but majorly when it comes to property and family and inheritance. So it's very important that we have all the stakeholders. And as you're aware, I know we've always had some people, allege that we're supposed to have given them prior notice, 2 weeks notice. But the structure or the way we hold these engagements is we want to discuss an issue that is hot at the moment, that is prevalent. And if you remember the beginning of the week, this week, and I think part of last week, the media, social media was awash with all sorts of information about expiring letters of administration, the issue of extension, and I extended, I think, to land, where people are saying your name could be on a title when you do not have ownership, and we are receiving so many questions. Personally, I was receiving questions from members of the public. Some of these are people who need, they are not lawyers. They are people who know, they have, some of these, they are likely to be affected by this. And who should answer those questions? They are the stakeholders. If it is not the Office of the Administrator General, if it is not Uganda Law Society through the members, if it is not the court where most people are running to, because everyone is being told that you have to run to court to renew your letters of administration because they've expired. So I would have really loved it if we had those people here, because the biggest challenge we have affecting access to justice is the knowledge gap. It causes so many problems. People are going to be misled. Others are going to do the wrong things. Others don't even know where to go. So it is our duty, it is our role as, stakeholders, jealous actors, to come up, to step up, because sometimes what I learned from where they were launching the arbitration and mediation center is that there's this gentleman who says that you'd rather tackle the problem before it actually happens, instead of waiting to resolve. So if we did this, probably would resolve, because I have my, I know Henry has extensively discussed the good things about the act, the Succession Amendment Act, these changes and the reforms it brought to do with especially expiration of the letters of administration. I have my, my personal views and, reservations as someone who practices in that area. And the reason I'm actually saying we really needed people like the judiciary here is most of the challenges or the issues that we're likely to face or that we're already facing from this kind of reform is institutional. Like you're aware, the judiciary is already grappling with, backlog. Lots of cases. There are even cases of, just grants. Grants, someone petitions court for a grant of letters of administration. It spends months. Someone takes months, they're not getting the grant. Now, There are some people who get the grants. You get a grant today, the following day, someone goes to court to challenge the grant. They have various orders, injunctions. You find these injunctions are being registered as encumbrances on certificates of title. The administrators clearly cannot do anything. And with the nature of backlog we have, these are cases which take over 10 years in court, 5, 6, 10 years. They are not shifting, they are not moving. Now, of course, these are, I think, some of the justifications where someone can say, we've not been able to ably administer this estate because there has been a dispute in court ongoing. We got letters today, the following day, someone filed a case. This case is not resolved. Now we're adding another, it's another application in court whereby definitely the other people who are challenging letters will also oppose. They don't want you to be, granted these letters. They don't want an extension because they were challenging it in the first place. There are various reasons. So I think as institutions in the jealous sector, we need to think, this is the time to rethink and say, is it just the laws? Is the problem the laws we have? Or the problems are different? Are the laws we have or the reforms we are suggesting or bringing, are they solving a problem or they are creating more problems? So this is why we need to have combined efforts and we work together. And as the Radical New Bar, we are really open to working with all these institutions to resolve these problems because, like I said, our role is to, to improve access to justice for the members of the public. So, like I said, those are quite a number of issues and challenges which would have answered jointly as the legal professionals, as from the judiciary point of view, and the Office of the Administrator General, and probably come up with solutions. But we are open to engagement. We feel we can have more discussions and come up with practical solutions, not just things that are on paper that are going to create more problems. Because my worry is, imagine right now in a day you have about 1,000 applications only filed at family division. When will they be disposed of? How many judicial officers do we have? And what happens to those estates during that period where court has not yet extended, this one has expired? There are things to be done in there. So I think these engagements, we should have meaningful engagements for to have solutions. And as I close, I want to speak briefly to what the Treasurer was mentioning about what is happening to the members of the bar, members of the legal profession, and what we're trying to do as the Radical New Bar to fight for the independence of the legal profession. Yesterday we had a delegation here from South Sudan, led by the president of the South Sudan Bar Association, and they have very interesting scenarios. I looked at their idea, and they have immunity. A member of South Sudan Bar, a lawyer from South Sudan cannot be arrested. The idea even reads immunity. This person cannot be arrested. I know it's a young bar. They are much younger than us, who are making 70 years, I think, next year. But these are some of the things they looked at, and there are reasons as to why that is done. We know it's something that is really far from reality here because of what's happening, but those are some of the reforms we think we can borrow from neighboring countries, because you can imagine spending the whole day running up and about. I was in Iganga yesterday trying to rescue a member who has been, incarcerated and taken, incommunicado for about 5-6 days. So those are other areas where we are trying to make a milestone. But again, also from the discussions we are having, we also open to, and we are strongly fighting for the independence of the judiciary, because we know if we do not have an independent judiciary, then the aspect of access to justice, that is going to be affected greatly, and everyone will be a victim. That's the members of the public, the judicial officers, the members or the lawyers who practice in those courts. So that is why those are some of the major aspects. So as I conclude, once again, I thank you for being part of this. For the members of the press who are always here with us every Thursday, we do not take this for granted. Thank you for being here, because you're also doing your role of, giving information to the members of the public who would have not gotten this chance or this opportunity. So thank you very much, and I wish you a good afternoon. I'd like to invite the speakers for a group photo. It's our tradition here that every after an engagement, we have a record of the same and the documentary proof, yeah, in form of a group photograph. You want us in front of that? You tell us where you want us.